My name is Garrett Gregory. I'm a former IRS attorney and co-founder of the Gregory Law Group, PLLC. Our firm specializes in representing individuals and small businesses with their domestic and international tax issues. Specifically, we assist clients with tax planning, audit, appeals, and tax court representation, and collection mitigation. Many U.S. citizens, both those living in the U.S. and those living abroad, are completely unaware of the strict disclosure requirements with respect to offshore financial accounts. Worse still are the harsh penalties that can accompany these failures to disclose the existence of these accounts. Under the Report of Foreign Bank and Financial Accounts, aka FBAR regime, any U.S. person must file an FBAR if 1. The U.S. person had a financial interest in or signature authority over at least one financial account located outside of the United States, and 2. The aggregate value of all financial accounts exceeded $10,000 at any time during the calendar year to be reported. The term U.S. person includes U.S. citizens, U.S. residents, and some types of entities. Furthermore, a U.S. person that holds a foreign financial account generally has a filing obligation even if the account produces no taxable income. A U.S. person who fails to file a required FBAR may be subject to a civil penalty up to $10,000 per violation in the case of non-willful violations that are not due to reasonable cause. For willful violations, the penalty may be the greater of $100,000 or 50% of the balance in the account when the violation occurs per violation. The dollar values of these penalties are serious in their own right. What's worse is that if you are found to have willfully failed to file an FBAR or to have willfully filed a false FBAR, you could be subject to criminal prosecution. In many cases, offshore accounts earn interest or other income. If this income is not declared on the U.S. person's income tax return, the taxpayer may have problems in addition to the normal FBAR filing requirements. To allow taxpayers in this position to get compliant, the IRS offers what is called the Offshore Voluntary Disclosure Program. This program allows taxpayers to come forward and disclose foreign accounts and the income earned by these accounts. As a reward for coming forward before getting caught, taxpayers can avoid extremely harsh penalties and criminal prosecution. These are complicated international tax matters that require experienced tax attorneys. The co-founders of our firm, Deborah Gregory and myself, both served on the IRS's International Field Council for a combined 24 years before starting our own law firm, Gregory Law Group, PLLC. Call our office today at 866-861-3640 for a free confidential consultation.